Hello, good afternoon, and welcome to The Law. This is your legal light and health law. I'm SAMSON, LARDY, ANYENINI. And this afternoon we are looking at bail. Anything and everything you need to know about bail. When you go to the police station, you are in trouble and you need bail. When you have to be taken to the courts, you are in trouble and you need bail. How do you secure one? Why are some people refused bail while others are granted bail? If you went to stand surety or guaranteed bail for somebody and the person absconded or they ran away, what's your fate? Will you be arrested? Will you lose your property? How do you ensure that this does not happen? Recently, Ekuapem Polo was granted bail even after she was convicted and sentenced to 90 days in jail. People have been confused. We will explain. There's no need for any confusion. Some were saying after she was granted the bail, she still spent days in custody because she couldn't pay the bail sum of 80,000 cedis. Was he really supposed to pay? If you have ever paid for bail, you threw some money away. We'll explain to you. We'll be right back. You're welcome back. I've asked you the question already. What comes to your mind when you hear bail? Why are some people granted bail and others refuse bail, either by police or the court, when they so badly need it? And as I reminded you, many people have been confused why Ekuapem Polo, for example, is on bail even when she was convicted and sentenced to 90 days in jail. Some said she spent several days in custody despite the grant of the bail because she couldn't raise the bail sum of 80,000. And I say, if you ever paid money for bail, you were duped. We will explain. But will you be arrested if a person you guaranteed bail for absconded? Here are some of your thoughts.
Bailing is like someone guaranteeing an inmate or someone in cells or prison for the person to come out for some time.
Bail is all about like bailing someone from out of the cell, or you can rescue someone from out of a kind of issue or a kind of problem. Yeah, just to set the person free.
Bail is like you're going to guarantee for somebody to be free. That's all I know.
What I understand by bail is going to stand as a guarantor for the person to be released from the police station.
Okay, when you talk of bail, bail means like you, the guarantor, you have to go into the police station and let's say maybe they put some fine on maybe the person who had become this thing. So they put the fine maybe 100,000 or so that if the person didn't come or they didn't see the person, that person who has been the guarantor, you have to go. They will come and collect that money from you.
Me what I not be say maybe somebody go do something or police arrest them. For normal circumstance, police for not hold them for more than 48 hours. So they will be say, then the jail you make it come out. You so say later then we'll call your case if they will take you go court or something. But then for guarantee give you say okay, yeah, so and so at this time, if police they hear you, they can catch you or something.
Setting the person from police custody with some sureties.
You're welcome back. This is the law, and this is your legal lights. It is your health law. My guest this afternoon to help us with the discussion, and we are discussing Bail 101. It's like when you enter a university and you are starting your program, you start perhaps with a 101 course. My guest is Martin Pebu. He's Senior Associate Lawyer at GT Legal Africa. Thank you so much for joining us.
Thank you, sir.
Right. And if you needed anybody to explain the issues of bail, you have the best. And as we go on with the discussion, if you are the only stranger in Ghana, you'll get to understand why I say we have the best. In due course, we'll open the phone lines as we always do for you to tell us what encounter you had in trying to secure bail, or you secured bail for somebody and they ran away, and what happened. Right. So let's start from scratch. When we say bail, what do we mean?
Okay. So, Sam, bail in itself now, it's a whole process. But let's start from the original meaning.
Okay.
Then we'll come to the added process. So the original meaning is that it's a promise, an undertaking, okay, an assurance, okay, by a person called a surety. In this case, since we are more used to the word guarantors, loans are more popular in Ghana, so we can put in the word guarantor.
Right.
So an assurance, a promise, an undertaking by a guarantor that when somebody is handed over to him or her, he will make sure that that person is brought to appear in court to stand trial. So this is actually in a criminal case.
Right.
So let's repeat it this way. So it starts that somebody has been accused of a crime,
right,
either in the police station or in a court, and then he needs to be released. Now, because we are not sure that he may come to stand trial, he needs somebody to guarantee. That's what we call the surety. I prefer to use guarantee because we are used to guarantee.
Right.
So that third person will guarantee to the police officers or to the court that hand over this person to me and I'll bring him anytime he's needed. So that's the core meaning of bail. Okay?
Right.
But before you get it, you first have to apply for it. So we also use the word bail to refer to the acceptance of the police or the judge to allow you to sign that bond, that contract. So the bail itself, you see that it's a contract form. There is a form. One is either the police station or in the court. It's a form that you sign.
Right.
So you have the terms. I, so and so, will produce Mr. X on this and this date when needed. And if in failure, okay, I'll pay this and this amount. So the sum is written.
Right.
Okay. So the most critical part often is the acceptance by the police or the judge that he will take your contract. That's the most critical part. So you hear them say, oh, the police have admitted Mr. X to bail. The judge has admitted Mr. Y to bail. So that part of the process is also called bail. So that acceptance, you say.
Okay.
Yes. So these two put together.
Right. Since the Constitution is the supreme law of the country, can we begin from the Constitution to have an appreciation where the idea itself comes from, so that if one is arrested, one is restricted or detained, then they can say, the law says I'm entitled, then they can go for it.
Yeah.
Right?
Yes.
What does the Constitution have to say? Does it give us a clue at all about it?
Yeah.
In Article 14, right?
Yes.
Article 14.2 says, a person who is arrested, restricted, or detained shall be informed immediately in a language that he understands of the reasons for his arrest, restriction, or detention, and of his right to be to a lawyer of his choice. And this is what we say is the Miranda right. So what it means is that at any point in time, if you have become a suspect, then you may be arrested, you may be restricted, and you may be detained.
That's correct.
And when you get into that situation, then you may need bail.
That's it. That's it. That's correct.
How do I determine that I should get the bail from police or get it from where?
Okay. So because most of the time, when a suspect is taken, it's at the police station or IOCU, okay, or BNI, now NIB. Right? Yeah, so usually it's the first point that you ask for bail. But if your criminal process starts in the form that the magistrate issues the warrant that you be arrested and brought, then that way is before the magistrate.
Okay.
Yes, so usually the first person you are taken to when you've been arrested is the person you apply to for bail. But let's add that...
So you are saying that normally, frequently, we know that it is the police that may arrest you.
Yes.
Or the other institutions you have mentioned, YOCO or the NIB.
Yes.
But it could also come from a judge.
That's correct. Yes, the magistrate. In the Act 30 is provided for. Usually, the police, what they do is that they use that method where the person is of such a stature that he refuses to come to the police station. And they see that if they arrest him, it will cause commotion.
Okay.
So that way, the police will apply to a judge, and the judge will issue the summons.
A warrant.
Yes, that he be brought.
That they should go and arrest him and bring him.
Invite him.
Okay. And so when they do so, it is not the police that will grant him bail.
No.
It will be the court.
Yes. It comes before the magistrate in the Act 30.
So the law, as I read to you earlier, and all of you earlier, says that if you find yourself in the situation that I spoke about, you shall be brought before a court within 48 hours after the arrest, restriction, or detention.
That's correct.
So explain that to us.
Great. Yes, so for good reason. And you know, this particular provision, I don't know why Ghana, it has a bit of history. Let's go a bit into it. We move 5 steps, let's say a step forward and then 5 backwards. In the 1969 Constitution, this 48 hours was 24. 24 hours. That's what we have in the 1969 Constitution. And nearby Nigeria, they also have it 24 hours. But I don't know, I think people were looking away. I mean, we all know that generally the criminal practice doesn't pay. So I take it that the stalwarts are not in that area. So when these provisions were being passed, people didn't check.
The Constitution Review Commission recommended that we go to 24 hours.
Exactly.
And it was rejected.
So, so it still comes back. My thinking about this area is that because it doesn't fetch money, all the stalwarts, the seniors in the practice, they are in the civil area. People are busy making commercial deals. They are not interested in somebody who's stolen a goat or an armed robber who is jumped into a house to steal television set worth 2,000 Ghana. So somebody who steals a television set worth 2,000 Ghana, how much is he going to get to pay you?
So previously in this country, if the police arrest you, they can't keep you for more than 24 hours.
That was the law, 1969 Constitution, when Buzia was Prime Minister.
Okay.
Right? So he was overthrown.
But now by the law, they can't keep you for more than 48 hours. So what happens?
Yes, okay, so they can keep you by their own say-so for only up to 48 hours. Beyond that, they will need the order or permission of a judge.
Okay.
And let's make this very critical point. I know we'll come there, but since we are, look, in Pebu number 4, that's Chief Justice Sofia Kufu's valedictory judgment. She said that, look, this 48 hours, and it's a unanimous decision. She says that as police, when you are seized with the matter, if from the outset it's very clear to you that this matter, at the end of, it's very clear to you that by the end of 48 hours, there's no way you grant bail. The court said, please start going to court immediately. Don't wait till the 48th hour before you go to court. So when it's very clear to you, so let's say murder, rape, you know, the offenses that the Supreme Court declared as bailable.
Right.
You know, it takes time psychologically before people will get harmed. So those offenses, when you go to the police station, they are not going to grant bail, like armed robbery. No policeman will grant bail in the police station, okay?
All right.
So the Supreme Court is saying that once it's clear to you that for this offense, you won't grant bail, don't wait for the 48 hours before you go to court.
Okay.
Just as soon as you can, go. So back to the simple answer to your question. The police have the power, IOCO, NIB and the rest have the power to keep the suspect for up to 48 hours. But don't wait till the end of 48 hours before you go to court, because the law says within 48 hours. So you have to be in court before the 48th hour expires.
Right.
So that then you make your case to the judge. Then the accused or the suspect can also make his case to the judge why he should be allowed to go home.
Okay.
Then the judge will look at it and balance it. The judge will do the count.
So earlier you were referring to certain offenses which you say it will take time for them to, for our minds to begin to accommodate that now they are also amenable to bail.
Yes.
And if the police are dealing with any such case, they should start the process of bail immediately and not wait for 48 hours, because most likely they will not grant bail.
Excellent.
All right. So these are the offenses that Martin Kpebu was referring to. Treason, subversion, murder, robbery, hijacking, piracy, rape, defilement, escape from lawful custody, extradition, if you are being held for extradition to a foreign country, narcotic offenses like for narcotic drugs, anti-terrorism, like if you are involved in terrorism acts. Initially, or for a long time, these offenses were not bailable. If you were accused of them, the police didn't have a right to say we are giving you bail. And even the court,
yes,
you know, because the law says they can't grant you bail.
Yeah.
But now, because of Martin Kpebu, he went to court and made the argument that every offense must be subject to bail. And the court agreed with him. So because of him, today, every offense, the court must consider the possibility of granting bail, including the police as well. So if the police arrest me,
Myself, very important.
Okay.
Let's extol this is the good work done by Chief Justice JoyNews, Justice Benning. They were the ones. You know, lawyer, when you go, it's not the strength of your argument.
That's true.
It's the court, because
nobody matters.
Yeah, but if you look at it, you read Justice Benning, you read Justice JoyNews, Justice Doche. You see them at pains that look, this law has cost us too much. Too much. That's why they struck it down. So they, for me, in my estimation, I believe that they deserve more of the thanks and the kudos for what we have to do.
We know you are being modest. We understand. Okay, right. So let's get to the practical side of it. Say my next door neighbor has accused me, or it's a domestic situation. My wife has accused me that I've hit her. Okay, touch wood, it will not happen.
Yes, I do.
And it happens. Then police will come in. They will arrest me.
Yes.
What should happen?
Yeah, so they take you to the police station. So this one, being domestic violence, is bailable, okay? It's bailable. So if you can furnish bail at the police station, they would say, okay, they want to take your caution statement, so they warned you. I like the way you like repeating the Miranda rights very often on this on TV, so that citizens are well informed. So they will read your Miranda rights to you, that you have the right to keep quiet, okay, or say something, but whatever you say will be tendered in court.
Okay.
So that you write your version if you want to tell a story. If you don't want to say anything, you will write that I will not say anything, because the burden is on the prosecution to prove that you committed an offense. So generally, after it...
Wait, please listen carefully. You are saying when the police arrest me and they take me to the police station, I have a right to say I'm not going to write anything.
Yes.
And I also have a right to say I will actually explain my situation.
Excellent. Yes, it's a right.
Will I not be in trouble if they say you must do something and I say I won't write anything?
I like that. Yeah, that's a practitioner. Yes. So what they do is that they punish you for it. Very often, if you don't want to tell your story, then they make it difficult for you. They make it difficult. And that's one thing that we encourage brothers, the policemen, to desist from. You see cases in which suspects complain because they don't want to say anything. Then they say, okay, then we'll not grant bail. We'll rather go to court and all that, okay? They won't give you access to your phone. You know, a lot of suspects have complained about this. Let me tell you one case where the Attorney General, just last Saturday, were in court, okay? That was a case where when they were taken in, I'm talking about the coup plotters case.
Yeah.
They were arrested on Friday, last
alleged
Friday.
Coup plotters.
The alleged coup plotters, thank you. They were so annoyed about the manner in which they were deceived into NID and arrested. So they said they will write nothing. We were in court on Saturday. The Attorney General didn't make any fuss about it. The court granted bail.
Okay.
Because the burden is on the prosecution. If you are holding your evidence, you are very sure of the evidence, you don't need the accused to say anything.
Okay.
It's your duty. So As of the time we're in court on Saturday, none of them had written anything.
Okay. So what would be your advice to somebody who really feels that and believes that they don't have to say anything, but because if they don't say something and they refuse saying anything, the police will say, we won't grant you bail, and they will have to stay there until perhaps maybe the 48th hour before they are taken to court. What will you say to somebody like that?
No, we should be resolute. You see, we should be resolute. We should let the law work. It's your right to be silent. Yeah, so if you are silent and they try to punish you, don't worry. After a while, the police will change. But it's your right to keep silent.
Okay. So
exercise it, of course. I won't say there's a price to pay. That price you're paying is illegal. But gradually, you see, can you imagine? You know this 96, the non-bailable offenses. I remember, just a few days before going to court, some lawyers, when I told them about it, they said, oh, listen, you will fail. The Supreme Court will throw you out. But it happened. So those who get punished, just persevere.
Okay.
You know, as we are developing, building more schools, more hospitals, these laws, criminal justice needs to grow, just like we are doing now. So maybe a police officer is listening. Then he knows that, oh, even the alleged coup plotters case, as of last Saturday when they went to court, they refused. They hadn't written their statement.
And yet they were granted bail.
Yeah, so he will see that, okay, I'm also a citizen. Next time, maybe my cousin in a different town, maybe in the village. Next time, maybe my brother. I mean, the case where now some 3 policemen are in custody over the alleged murder of a little boy. You see, so it happens to police. It happens to lawyers. We are all citizens. It can happen to anybody. So that we all must be mindful when we are applying the law, that today you are applying to your fellow citizen and you are twisting the law. Tomorrow it may be your mom or your dad.
So there are those who may decide that they don't want to say anything, and there are those who may decide that I don't want to say anything until I have a lawyer.
Yeah.
Can the police insist that they should go ahead and write whatever they have to write because they have to do it quickly?
Not at all, as you rightly said. Not at all. They can't force you to say anything in the absence of your lawyer.
Okay.
Yes.
And what's the benefit in waiting to have a lawyer before you write something?
Yes, you know, the lawyer, number one, when you have the lawyer at the side of the accused or the suspect, it helps him, okay? It helps him psychologically. You know, sometimes when you are alone, even that fear alone, you may make mistakes in what you want to write.
That's right.
But when you have somebody by you, somebody close to you, somebody you have confidence with, it brings up your spirits, it boosts your morale, and you are in a better mental frame of mind to write better. So that apart. And then secondly, there's a one that you check with your lawyer, this, so that lawyer will help you put it well.
Right.
So it helps.
Lawyer may explain the offenses to you.
Perfect.
The potential consequences.
Perfect.
Then you can make a determination to say, well, this one, let me take it, or this one, let me fight it.
Perfect.
All right. So far, if you haven't heard anything at all, you have heard that once the police arrest you, and it could include any other law enforcement body, all right? Once they arrest you, he spoke about something. They are supposed to read out your Miranda rights to you. Your Miranda right is what the law in our Constitution says. They must talk to you in a language that you understand. Explain why you are being arrested, and then proceed further to tell you that you have a right to be silent, and that if you chose to say anything, the things you say may be used against you in a court of law. And finally, to inform you that you have a right to a lawyer of your own choice. Then, at the police station, they will ask you to write a statement. If you are asked to write a statement, you have a right to determine that you have nothing to say, or you want to explain. If you have the opportunity to wait for some lawyer to come to you and help you, he says that will be a good thing to do. But the police are not supposed to deny you bail unnecessarily. If they make a determination that the case that they are dealing with is not something that they would give you bail, but they will take you to court, they shouldn't wait until the 48th hour before they take you to court. They should start going to court immediately. Right. So what will they normally look at to determine that they can give me bail, or they must go to court to give for the court to determine whether one should get bail or not?
Okay, so usually the first one is the category of offenses. As you've already said, when they hear murder, manslaughter, rape, defilement, the ones you read, the hitherto non-bailable offenses, they are likely to go to this in court rather than grant you bail. Okay, that apart, the next one is the stage of the investigations. So the one we said, if you don't write anything, so when they don't know where your mind is, then, and especially when their evidence is not strong, then in that case, they rather want to go to court so that they will tell the judge that they are still investigating, they need more time. You see it. So the stage of the investigation is usually the second stage. That's very, very, very crucial to them.
Okay.
Yes, if the evidence is not solid, they need to hear you. They want to go to court. If you are not giving them your side of the story, they want to go to court. Then number 3, they are talking about the issue of fixed abode. Who is the person they are dealing with? If the person doesn't appear to be a person of means, a person who has a fixed place of abode, and when we say fixed place, it's not just that you live in house number so and so. No. As part of it, they want to see if you are deeply rooted in Ghana. Do you have a wife? Do you have the children all in Ghana? Are you Ghanaian? So you know here, this is where some foreigners are disadvantaged. Because if he doesn't have this, usually, no. They know that because our borders are porous, when he's granted bail, he will jump. He will go back to his home. Okay, so they're here to the nationality of the person, especially if it's a West African sub-region here, it's very hard.
That you have a fixed place of abode, that you are married, perhaps, and that you have children is one consideration that influences police and also the court to think that when you are granted bail, you will not run away.
Yes, very, very, very important. Yes, very crucial, because
people don't understand. Why is it that some people go to the police station and they grant them bail without any stringent condition? They simply show their ID card or something, and then maybe a police officer goes to see where they live and they grant them bail. But some other people, they say you must bring this, you must bring that. What's that?
It's the gravity of the offense. So let's say that Miss Y has been accused of stealing, let's say, 100 million from her employers. That's certainly far more serious than Miss X, who probably has slapped, excuse me, this is a co-tenant. So conduct conducive to the breach of the peace, or let's say assault, is certainly, we know they are all offenses, but there are categories, grades and the rest, okay? That's a misdemeanor. But the stealing is, this is second-degree felony. So the graver it is, then the more the conditions, okay? So that's generally the factor, how grievous the offense is.
There are situations and people have either arrested the person and taking the person to the police station, and the next time they see the person around and they are so angry, what will you tell them? Because they feel the police is not doing their work by allowing that person to come out of, custody.
Yes, what I should tell those people is that, please, their first point of call is to go to the police and put pressure that they should prosecute the case quickly. They should prosecute the case quickly, because some, you know it very well in practice, that you see the justice for all. They freed about 800 persons. People, and then listen, Kwame, your colleague journalist here.
Yes, Kwame Boateng.
Locked and forgotten. You saw how people were packed like sardines, fellow human beings. Okay, so for all those reasons, that's why the bail regime is being modernized. Okay, so if the person has been admitted to bail and you are angry, please, anger can be positive energy. Use it to follow up with the police. Go and monitor the case. Yes, Inspector, when is the next court sitting? The next court sitting, go to court. Watch what is happening. As you are monitoring and interacting with the police, they get serious that, okay, the victims are here. Even if you are not complaining and you show interest, then they can prosecute the case quickly. But the remedy is not to say, oh, police are freeing people. No, it's, what do you call it, rule of law. The democracy is not only about the hospitals and the schools. It's also about personal liberties. It's in the same constitution.
So the fact that you really believe that this person, we caught him in the act and we took him to the police and police have granted him bail, is not basis to accuse the police of perhaps having taken a bribe and let the person go.
Yes, yes.
But because bail is available to everybody.
That's correct. That's correct. So in that regard, we should stop bastardizing the police service. It's not good. I mean, we should stop those, okay? That's why I said the best is that, so from this same Constitution, Chapter 5, Fundamental Human Rights. You see, and as we sit here, look, let's say this, sometimes viewers think that, these guys, when you say human rights, have you ever felt crime and the rest? Please, as I sit here in my home, I've been burgled in my car. Same.
I've been burgled.
You see, so I felt it. You know, when thieves have entered your room in the night, even though you didn't meet them, the night is hard to sleep. You are traumatized and all that. I felt it, but that's not an answer, because let's not forget, it's not about them. It's about us. It may happen to me tomorrow. So it's better that we put in place systems. You see now, Army Colonel, you see ACP Agwajoenko, who thought such persons should be before the court?
Okay, so what can the police ask for, or the court ask for, in granting me bail?
Okay, yes, so usually when the offense is very, very grievous, the court will go for the maximum. So they ask for security, collateral, saying that the surety should provide security, and the security will be verified. So let's go over step by step. So the judge will typically say, so let's say offense of robbery, he's denied it. So the judge will say, okay, accused is admitted to bail in the sum of, depending on how much was stolen, maybe if let's say 50,000 allegedly. So the judge, and we'll come to that, there are no guidelines as to how much they will set, but often judges will double it. So you hear the judge say, accused is admitted to bail in the sum of 100,000 Ghana cedis with two sureties. One, to be justified. Please, we'll underline the word justified. So this means you would have to bring property. Of course, you can't carry it. Usually it's land. So you bring land documents, okay, and the land should be worth at least 100,000. And when you bring it, even the most difficult part, and we'll come to that, is that the court will go and conduct a search. Please, and that search, if you are not careful, you can spend 1 month. So the judge is finished in 5 minutes. Accused admitted to bail in the sum of 100,000 with two sureties, one to be justified. You bring your land title. To type the court letter alone to Lands Commission can take you 3 days. You go to Lands Commission. If you don't, facilitate, you don't pay your way around, it won't get done. This one, we have to be very honest about it. If not, we'll not get solutions. There's no way you can get a search out, no matter even what you pay, in 1 day. So typically, before you see 1 week, 2 weeks, even they themselves, official, they'll tell you 2 weeks. And these 2 weeks, if you don't follow and pay, nobody gives it. Those are huge problems that we should be looking at. Because please, viewers, as you view, let's all do it. They say when your neighbor's beard is on fire, you find water for yours. The water for yours is what we are discussing, so that will all be free. So that if police were to come to your house, you know that, oh, well, if I go to court, they grant me bail. Within 2 days, I'll get a search from Lands Commission, and then I can leave the police station. Why can't it even be within 24 hours? Can't we understand Lands Commission is modernizing, but it's another problem altogether? So that's the thing. So your question was that, what are the conditions? So that's the maximum that we've stated. But the judge too could have just stated that he's admitted to bail with two sureties. If they don't add the word to be justified.
Surety to be justified.
Yes, in the sum of 100,000 cedis to be justified. So it's a sum that you are justifying. If they don't add the word justification, all that it means is that, okay, if the person runs, so you go and sign the agreement, the bail bond, that you pay 100,000 if he absconds and you cannot produce him. Then the next thing is that is the registrar of the court who has to go and inspect the surety's house. But registrar usually is too busy, so the police do. That's another area we should be looking at. Some of the
so when the bail is given by the court, and the court said this bail is given in this sum amount of money, with maybe 1 or 2 sureties. He had explained earlier that the surety is your guarantor, the person who is coming to stand in for you. The judge can simply say, with 2 sureties, it ends there. When the judge says so, then it means nobody is supposed to produce any property document or maybe some financial investment documents to guarantee or secure your bail. But once the judge says, with surety to be justified, justified means that they must bring something of the value of the bail amount or sum. And that is where a bit of a difficulty might begin, right? So when they say it's not to be, are there not situations where they don't even say anybody else should come in?
Excellent.
But you yourself?
Yes, self-recognizance. Once again, maybe you remember Abu Gapile, I think those days, whilst he was standing trial, he got self-recognizance. And that's important because being an MP, he has at least hundreds of thousands of constituents. So such a person is unlikely to run away. In the alleged coup plotters case, ACP Agojo, also for 1 year, he was on the
self-recognizance bail.
Yes.
And the self-recognizance bail means that we believe that you are worthy, you won't run away. Yes. You yourself, you use your name to get your bail. Okay, right. You're still here on the law, and we are discussing bail. My guest is Martin Pebu. We're discussing bail. We'll open the lines very soon. You tell us your situations that you may have encountered with the issues of bail and what help we may be able to offer you. The law says bail is not to be used as punishment. What does that mean?
Yes, excellent. So, yes, so meaning that you refuse the person bail in a manner as to punish him. So meaning that he qualifies for bail, but you won't grant him. So like the one that we've mentioned, the other earlier example, two co-tenants fight. Normal assault is not to be encouraged. We are not encouraging it. But such an offense, okay, ordinarily the police will grant bail. It's not one for which they will keep it. But sometimes you see that they say the aggressor or whoever, one of them is so insulting, she's rude, she's this, so we'll keep you, we'll not grant you bail. That's it. Don't use personal sentiment.
Can the police, at the level of the police, can they ask me to bring money?
Not at all, not at all.
Do they do justified at the police station?
Not at all. So that's by the books.
Okay.
But I've heard one or two cases where practically they say, okay, look, hey, come and park your car. It's not, you know, in every society, these things, there are bad nuts. In every profession, you'll find one or two bad apples. That will give the rest a bad name.
What we have been talking about justification happens at the court.
That's correct.
And the police is not also supposed to ask you for money.
That's correct.
Before they are granting bail.
That's correct. But Sam, let's face the truth. You see, often when your liberties have been taken away, and then suddenly they are going to grant bail. Look, even me, let's say the truth. Sometimes, out of gratitude, we give something. But then the one that we should be deprecated is the one that the officer is extorting. Sometimes they take your client behind you and extort. Pay us this sum. Look, lawyer, it's my power to grant. It's not lawyer, so give me this money. If not, you are not going. And that is a big problem. Look, if we can't speak the truth, we are finished. I mean, we are lawyers. If we can't, it's a huge problem. Let callers start calling. They will tell you the extortion is just a big problem.
Somebody had informed me in somewhere in Tamale, and he said the officer asked for money, and they had to pay. And they couldn't pay the exact amount. So he was waiting for the rest of the money to be paid before their relative will be released.
Yes, it's a huge problem. If we can't talk about this, then I have no business being a lawyer. It's huge. Look, we should stop it. You see, we ourselves, I don't know, somehow we've been socialized in such a way that, as I said, I admit that if the officer doesn't ask for anything, when he's cooperated and the rest, look, you talk to the accused and say, look, you give him something. And that's why I said now, we are talking about, we will examine how it looks like as you are growing up and you are being socialized. You just come to do it. But the extortion where they put a price, look, about a month ago, it happened to me that way. The court granted bail. The officer will not go and inspect the house. He had to take 1,000 from the client. If the client wasn't going to pay, he was going to say no.
So the 1,000 is in the name of TNT to go and inspect the house, and all the time he's good. Meanwhile, the work he's doing is being paid for by the state. At the end of the month, you get a salary.
That's it. That's it. Yes, they will complain. You see, even though I'm aware when this government came in, so far they've given over 400 vehicles. But the vehicles are not for going to inspect suspects. That's the thing. So maybe IGP should look at it. They should be some of the vehicles allocated, because government is giving over 400 vehicles, right? Yes, so maybe they should give it so that this thing should stop. Because look, all my hair is going since we started practice. It's always been there. Sometimes the suspect has to use his own car or his family members.
Right.
As we build schools, let's also build the criminal justice system because, hey, nobody knows tomorrow. Yeah.
So you are here on the law. This is your legal light and health law. As you can see, we have the Zoom meeting ID and passcode on the television you're watching. So we open the phone lines. Also, you can join us if you have any issues, you want to understand something about bail, let us know. But my first question to you now is, recently, this lady, Ekwaping Polo, he had been convicted and sentenced to 90 days in jail. And she made an appeal. Then the court granted her bail. People don't understand. They say, what is going on? You have been sentenced, so how come you get bail again? Can you explain that to them?
Yeah, so the law allows for post-conviction bail. Yes, it's allowed. Ekwaping Polo's one is not the only one. There is here Baden versus the Republic. Okay. There are other ones, Oku.
Okay.
Actually, Fin. You should start with Fin.
Okay.
Yes. So, listen, what do you call it? Bail after conviction is allowed, except that it's far more difficult. Yes, because you see, initially, what happens is that when we start, they say the presumption of innocence, the Article 19, Clause 2, right? So the court should grant bail, pending trial, blah, blah, blah. But after the trial, for good or bad, you've been convicted. So when the accused has been convicted, that presumption no longer applies.
Okay.
So after the person has been convicted, to get bail is extremely difficult. Extremely difficult.
Okay, I've got, is it Luis? Hi, where are you calling us from? Okay, Luis Achu Mensah Asankregwa.
Right.
What's your question?
Right. Good afternoon, Samson and Martin.
Good afternoon.
Right. Thank you for educating us on the law, for we innocent and novices of the law. In 2004, I was the chairman of the unit committee. I was arrested for standing bail for a grader driver who jammed into someone's building for constructing a road, and I was arrested. He absconded, and I was arrested. The real contractor was also at Tamale Okekos. He didn't attend to any of these cases. What should I do?
You were arrested, but as you speak, is there a case that you are attending to because of that matter?
Oh no, I have to go through or bear the cost of the cost of the building before I was released.
Okay, all right. Bennett, you are calling us from Krobodumase. What's your question?
Thank you, Senator Samson. God bless you for introducing this program. What I wanted to know is that somebody was arrested as an accused person and was sent to court, and the court orders the person to go and stay in police custody. Who asked for bail for the suspect? Is it the police prosecutor or the suspect lawyer? And again, in Kobo here, as a matter of fact, bail is not free. Not only Kobo here, within the judiciary, the region itself, bail is not free. Sometimes somebody tells you that, oh, I have a case at police station, and I was asked by the police to bring 200, 300, 500 cities for me to be granted bail before the case continues. If I don't bring it, I'll be there to 48 hours.
Okay, thank you, Bennett. So we can start with Luis Achu Mensah, who called us earlier. So what do you have to say to him? He's saying that he stood at Shorty, and then the person ran away, and he was arrested.
Okay, so number one, that arresting you, that one too, thankfully, you know, when the Supreme Court started modernizing the law on bail, they started from that point. So they've struck down the law that allows them to arrest you, the surety. Okay, that was in December 2015. Okay, so now if the person absconds, it's a civil case, meaning they will take you to court. So they will serve you this an application for forfeiture, okay, of the recognizance. Then you come to court and explain to the judge, if you can pay all the sum, if it's 100,000, you can pay all. So you show your means. If the means are said that the judge decides to give you a rebate and say, okay, pay 50,000 or pay 40. Yes, the judge has that discretion. Then you pay the money. But it's not for them to keep you. Hitherto, the court could convict you, so to speak, convict in quotes, and keep you for 6 months. That's what the Supreme Court has cancelled.
So now, once again, and Martin doesn't want us to say it, once again, through what he did, the court has been very clear. No one who stood surety or guaranteed bail should be arrested and put in custody or anywhere because the person they stood bail, they guaranteed for has run away. Rather, if you use a property, whatever you did, they may call on that one, okay? Or, as he said, you will be called upon to pay the money because it's a contract between you and the state. Then we had Bennett. Bennett.
I remember a case you and I did in the High Court, right? This surety thing. Yeah.
So Benjamin, hold on briefly. Bennett's question.
Yes. So Bennett says this is the very thing we're lamenting, that the police say bring 200, 300. Yes, that extortion must stop. That extortion must stop. You know, and the various IGP, they've warned from time to time. So we can only repeat that, please, don't extort from fellow citizens. Please, and by this, we are not painting all the police with one broad brush. No,
that's correct.
We are talking about the bad nuts. And we cannot run away, even in lawyers. I mean, as a profession, we also have bad nuts. Doctors, every profession is there. So when we sit here and say some police are extorting money, please, we are not preaching and behaving holier than thou. We just have to call out those who are doing the wrong thing so that we can correct it and move forward.
Okay, so if you don't give them, if some policeman asks you money and you don't give, you simply are waiting for 48 hours, then they will take you to court.
Yes.
And then as for the court, no judge is going to ask you to pay money.
That's correct. And when you finish, please, there's a police PIPS. They've changed the name. You can go and report at the police, what standards. It used to be called PIPS. They've changed the name.
Benjamin Somenya. Let's hear you, Benjamin.
Okay. Sir, good afternoon, sir.
Hi.
Okay, Mr. Martin was talking about the extortion of the money. So in that case, my point is that what are we doing about those people? Because we can't just let them go free. So what is the measures to correct
thank
that?
you,
Because
Benjamin.
my point is that if those people in power who are to enforce the law are rather abusing the law, then where are we heading towards?
You have a good point. Thank you for that contribution. Aaron, you are calling us from Techiman. What's your question?
Yes, my question is that if an assault case is alleged against somebody and is arrested, then the complainant stands back to say that the parents should come so that they will do a settlement or it doesn't want a court action. And the parents who are not forthcoming. And the person who is getting due. As a policeman, are you supposed to lead the person to go or you will have to force and send to court? Second question is, when somebody is being granted bail in a law court, in a criminal case, whose duty is it to inspect the place of the abode of that person?
Okay, Martin has already explained that, but he will explain again. Thank you very much, Aaron. Yes, let's hear you. Yeah.
So the first question was about the extortion. I like the way he repeated it. I think what we should say is that Ghanaians should be bold, okay? When the extortion, you see, when he makes the demand, even when you don't pay, because there's been an attempt, you can go and report. So we should do more of the reporting. Research shows that often we don't like reporting officials for this because everybody is scared. They will say that when they sack me, I'll come to your house for food. Like you hear it. Then the next thing is that let's keep talking. Let me borrow one of your favorite sayings on your shows. That sunshine is the best disinfectant. So if you don't talk about it, you don't bring it into the open, it won't get, resolved. Okay.
And the next person appears to be a police officer.
Yes, so that one, I know in some police stations, what they've done is that they take some opinion leaders in the community. You know, some families, when you get trouble, they wash their hands. Our family is not involved in crime, so nobody wants. So some police station commanders have some opinion leaders. They call the person, he comes, and then they ask, do you know this and this person? When they check and he knows, then the opinion leader stands. So as surety.
There are people who say, me, I will never guarantee bail for anybody.
Yes. Yes, please, let's not do that because look, currently, do you know something? We asked for some statistics from the prison service about 2 weeks ago. We have about 200 fellow citizens. They are in custody. They cannot meet the bail conditions. So maybe we should be thinking of an NGO that will work in this area.
I have 2 clients. They sue surety for a friend.
That was it.
The person has absconded. He's left.
Yes, I know. That was
now
the case.
Their property is at stake.
Yes, yes.
All right. Let's go to Zoom. Solomon, let's start with you. Quickly, hello, Solomon. Unmute, unmute. Oh no, Solomon, unmute. Hello, Bukari.
Hello.
Yes, go ahead, Bukari.
Yeah, good day.
Right, good day.
I'm speaking from Tumu, Upper West. I want to find out from Mr. Kwegu, this issue of bail. The other time, one of my relatives was involved in an issue. So he was taken to the court, and I was asked to bring my pay-in slip to be used as something that they can use before they can give that person bail. So I don't know whether it is right for them to ask for my pay slip before that person could be granted bail.
Okay.
All right.
Should we answer that?
Yes.
That one, you know, so let's be clear. What they've said, the Supreme Court has said that this issue, especially this paying slip, often it comes in the context of a government civil servants. Supreme Court has said no, the court should stop putting pressures on civil servants. So a court grants bail and say a civil servant earning pay within this range. No, no. I remember Justice Doche has had trainings with some of the lower judges, lower courts, where he's educated and no, we should stop that practice of saying senior civil servant must be earning 2,000, must be earning 2,500.
So this was the situation where the judge needed to see, or they needed to see the slip, the registrar, to be sure that the judge says you must be a civil servant and you must be earning this amount of money.
Yes, and we are saying that the Supreme Court says no.
It should not be done. Okay. Is it Shanga? Okay, hello, Jemfi on Zoom. Hello, Jemfi, let's hear you.
Hello, Samson.
Yeah, Jemfi, go ahead.
Samson, good afternoon. Great. My question has to do with the fact that, so from what Mr. Pebu is saying, it seems that bail has to do more with discretion. My question is, the law seems to give the judges a lot of power to determine who to admit on bail and who to refuse bail. Doesn't the law give too much power to the judges? Because I heard Mr. Pebu say that bail is not supposed to be a form of punishment.
That's right.
But since we do not check the exercise of discretion, don't we think it can, even though it's not supposed to, it can be a form of punishment?
All right. Thank you very much, Jeffy. Your question is perfectly understood. Yes, Martin.
Yeah. He's really hit the nail on the head.
He's speaking law.
Yeah.
He says bail is discretionary.
Yeah, discretionary. Yeah. So it's a judge who will look at it and do. So what can we do?
But the Constitution says when you are giving a discretion, you must exercise it in a certain way, not capricious, not unfairly, and all of that.
Without bias, without prejudice, Article 296.
Right.
Yes. So, well, that's the Constitution we're taking for ourselves. So we should be looking to increase it. So in terms of bail reform, what we should be looking at is that we should graduate. So when we say stealing, elsewhere in America, because they've imprisoned too many people, they have done reforms where now they are allowing a lot of self-recognizance bail. Self-recognizance, because so that too many black men and women were in jail. So now they are doing it. So you say, if the sum is, let's say, 500,000 Ghana, self-recognizance. If you show you are gainfully employed, so we need a lot of reforms in that area. And also the wearing of electronic tax. Yes, let's bring it into the system. So
but in a country where our address system is not the best, you say, good. Then the next time you can't find them. Shanga and Al-Hassan. Al-Hassan, you are calling from Navrongo. Let's hear you.
Yeah, good afternoon.
Hi, good afternoon. Please be quick. We are running out of time.
I want to know who should apply bail for an accused person. Is it the lawyer or any citizen.
Okay, somebody asked that question earlier. Is it the lawyer or any citizen or the prosecutor who will apply for bail for the accused person?
So if it's in a court of law, usually it's the accused person's lawyer. But if he doesn't have a lawyer, usually we have very good judges, quite a number of them. He just grants the bail. I've seen quite a number, and sometimes you see it's a big offense. He's looked at it and say, look, I will admit you to bail on this and this. And so the judges do a good job.
But the prosecutors don't ask for bail?
No. What they usually will say is that they are not opposed.
Okay.
They are not opposed. That's what they say.
All right. So for you and the one who earlier asked about who should ask for the bail, it's your the lawyer of the accused person, or you can ask it yourself in the courtroom if the judge is not minded. But there are judges like Martin Pebu says, they won't even wait for anybody to ask for it. Once the police read their facts about the case and they finish and they ask you to plead, you say you are not guilty, then the judge will write, and then by the time she's done, she will lift the head and say, you are admitted to bail in the sum of so and so and so. Nobody will ask for it. Okay, is this Shanga? Shanga calling from VRA.
Case of Martin Pebu and the Attorney General. I want to know, it was established that now all offences are bailable. Does it remain in practice, or is something that we should consider as theoretical?
Okay.
Do you understand?
It's a very important question. So let's say that the simple answer is that in some parts it's being implemented, other parts in some other courts is theoretical. Okay. So some judges are implementing it well, others who are not. You know, it depends on the human being. Let's not forget the law is in the book, but the human being who is come, you don't know what trauma he or she has suffered in life, what armed robbers have done to his or her family and the rest. So those things affect. Judges are also human. So it is bound to happen that not everybody will implement it the way we desire. But as we keep talking and exhorting them, of course, we'll get improvements.
Okay. Thank you so very much, Martin Pebu. Martin Pebu is a senior associate lawyer at GT Legal Africa. GT Legal Africa. And he's done a lot of work in this area of bail, ensuring that now there is no offense that can be said not to be liable to bail. And if you stood surety for somebody, you will not be arrested. Rather, if the person runs away, you will not be arrested. Rather, you have to pay for the amount that was put on the bail, and you may lose your property. Thank you so very much. This has been The Law. It's your legal lights and your help law. I'm SAMSON LARDY ANYENINI. God willing, next week, same time, we'll come your way with another edition.